right, good afternoon, everybody. Thank you for joining us again. My name is Eric Boughman. I'm with the law firm of Forster Boughman here in Central Florida. We are a business law boutique. We handle matters involving corporate and tax, asset protection, and do a lot of work in technology and healthcare. Today's topic is the potential perils of health and medical devices connected to the Internet of Things, Part 2. So we started this last month with my guest, Tony Peasy, who's the president and CEO of TechSpring, a technology company. And I have Tony on, who I would like to introduce. Tony, you want to say a few words?
Hey, Eric, thanks so much for having me. I really appreciate it. Hey, if anybody wants a copy of this presentation, it's in the handouts section. So just go to the handouts section. You can download it there and follow along with us.
All right, and we are approved. Last month, we had the CLE number for last month. I think the CLE number for this webinar for your legal CLE credits, if you need that, is pending. We may have that, or if not, we'll have it within the next couple of days. So with that, I'm going to move into our agenda for today. We are going to do a quick little introduction and a background, kind of summarize where we left off last month as far as some devices and risks. And we're going to do a little bit of a deeper dive, not too deep. There's a lot of material there, but a little bit of a deeper dive into law and regulation and some best practices. And we're talking generally about artificial intelligence devices and wearable technology and other devices connected to the Internet of Things, which really sometimes come as an afterthought with respect to security and privacy issues. Although they're hitting the news more, we see, of course, another big breach with a credit card company that just came out, apparently an insider hack, and then another article of interest that Tony and I shared this morning. I've seen this before with Amazon, but now we've got a whistleblower at Apple who says that everybody speaking in the presence of a Siri device is at risk of being recorded, and several conversations that are not intended for Siri pop onto the Siri recordings and are reviewed by Apple personnel. And apparently, one thing that I took that was interesting from that article is that a zipper, the sound of a zipper apparently triggers Siri to start its recording. So several conversations were specifically mentioned involving doctors and medical transactions. So something else to be aware of that we've talked about before. Tony, what did you think of that article?
Yeah, no, it's the same thing that we've been saying. I mean, you wrote an article, I want to say it was like over a year ago, about Alexa. And it's just, if the sound is very similar to the wake word, the device will pick it up. It almost reminds me of like the clapper in the old days. You'd have a clapper where you'd clap your hands and the light would go on. So that wasn't listening for anything very specific, but it's like the technology got refined, but it's still not fine enough because it's picking up a lot of erroneous information, which unfortunately is leaks of privacy.
Yeah, and really the reason to be aware of for a lot of the folks on the webinar today, for professionals, those specifically subject to confidentiality rules of fiduciary duties, is that if you are an advisor or a physician, if you're giving confidential advice or having conversations, and you have one of these, either an AI device or even just a phone that can be where Siri or Bixby or whatever your Google can be triggered, you need to be aware of that with respect to privacy concerns. So moving into just a little recap of some of the stuff we talked about last month. We have our national coordinator for Health Information Technology Office that has discussed the growing use of tablets and smartphones, specifically the use of health and wellness apps, everything from dieting and nutrition to exercise to health monitoring, and also mentions that several of these devices are used to communicate with healthcare providers. And the reason that's important for folks to be aware of is that several of those apps are not subject to the same confidentiality rules as specifically entities that are covered by HIPAA. So it's really the Wild West when it comes to a lot of these health and wellness apps and wearable technologies. Skipped ahead there. There are some benefits to the technology and wearable devices. Obviously, it allows people to be more connected to their health and fitness, both goals and concerns. There's the potential for health and wellness app data to be integrated with health records. And of course, it can streamline communication, but the streamline in that communication can come with some trade-offs and risks. I deal on the legal side, Tony deals on the technical side, and when we talk about what those risks are, some of them, the big concern is that health devices, wellness devices, apps, connected devices, everything from the wearable Fitbit or walking meter to your smart thermostat in your home, people don't consider those in the same sense as regular computers and computer systems when it comes to security. I don't think people think about their Fitbit being hacked or monitored like they do their computer. So everybody's concerned about jumping on a public Wi-Fi, but nobody seems too concerned about turning on a fitness monitor that tracks their movements throughout the day.
Even more so, Eric, I think what we're seeing now is more and more apps geared towards health, wellness, and just improvement of things. We're seeing hundreds of these apps out there. I mean, we're going to get more and more, and I think people don't give the same, I guess, the same security thoughts as they would for a device. So you're seeing even less so on, like you said, a device like a Fitbit, but I would say even less on an app that's just on your phone, something you downloaded, whether it's something monitoring your heart rate or some type of health indicator, or if it's something that's helping you with another health feature like maybe speech therapy or something that you need. These apps are collecting all this data, and as we said last time, you can't get the use out of your phone or out of your devices if you're not giving them data. So you need to give them data. It's just a matter of how's that data being stored and who else can access that data to prevent the leaks of privacy.
Yeah, and one of the things we talked about last month was a recent study that came out where researchers in California, I think it was at Berkeley, used publicly available or data that was available, maybe not public, some of it could have been publicly available, but in one circumstance they pulled information right off of Facebook, which essentially is publicly available data. You can limit your sharing to your friends, but oftentimes their friends can see what's going on. But these researchers were able to take information that's not subject to stringent privacy protections, mix that, or essentially bounce it off of information that is confidential and subject to HIPAA protections, and take anonymized HIPAA data and re-identify the individuals. So they could take individual data that people thought was being maintained confidential and secret and re-identify it. And Tony, maybe you can explain if you know a little bit more about how that process works. That might be interesting for people to understand how.
Yeah, there's certain data points that you need. For example, if you have someone's birthday, their sex, their zip code, you could probably narrow them down a lot quicker than most people would think. So you really don't need that many data points. But if you have some specific ones, you can take anonymized data and re-identify it. And that's what scares people, because you need data to do testing, you need data to run the systems, and you want to try to take the personalization out of it. But as soon as you put more data points in, you run the risk of having it being able to be re-identified.
Yeah, and thank you for the explanation. I know when you talk about some of the publicly available data, one example they used was taking somebody who was pregnant and being able to match that up with visits to a baby doctor and re-identify the person. But several different examples of that, and things for people to be aware of when it comes to sharing. And I think we're going to see more regulation over these devices as time passes. And we'll talk about a little bit of some of the laws that affect the devices outside of healthcare, but just generally. Again, why is this important? On the dark web, people are paying big money for health records and health credentials. Identity theft is also a big issue. The FTC has a lot of information on identity theft. The IRS has issues with identity theft and fake tax returns every year. And just having health credentials or health records can be quite valuable for nefarious use. So jumping into a little bit more specifically to law and regulation, and what governs the oversight of these devices, what governs the privacy concerns. We start with, at the top level, our Constitution and Fourth Amendment privacy protections and the limitations. First thing is Fourth Amendment generally only applies to government actors. Now we know, as lawyers know, that sometimes gets expanded so that if you're an entity or agency who gets federal dollars in some circumstances, the Fourth Amendment can be extended to you. But it is still worthwhile for people to understand that Fitbit devices, heart monitors, pacemakers have been used in criminal investigations. Last year, Tony, you made reference to the article, I wrote an article in Forbes a year or two ago on this, the issues that came out of the Amazon Alexa case, where the Alexa was, Amazon was subpoenaed for Alexa records that were sought in connection with a murder investigation. So government actors can get information from companies like Fitbit or from Apple or seek that information. In some circumstances, they're successful in obtaining it in connection with investigations. And although it doesn't really apply too often in the business context where we operate, we're not criminal lawyers, but we do see it sometimes in administrative investigations. Healthcare is subject to stringent federal oversight. Over 20% of our federal budget involves healthcare spending. So we do have a lot of government actors in the healthcare arena specifically. And as well, over the last few years, there's some cases that have come out that have really opened our eyes to the capabilities of government agencies when using and obtaining some of this data that we think is pretty innocuous. A couple cases of recent note: U.S. v. Jones was a case in 2012 where a tracking device was placed on an individual's car, and that data was used to help obtain a conviction. A criminal conviction against Jones. Ultimately, the Supreme Court reversed that search as not based on a fundamental right of privacy under the Fourth Amendment necessarily, but it was really based on a physical trespass of putting the device on Jones's car. But from what we learned in that case is that federal authorities and law enforcement authorities were able, by tracking Jones's movements, we're able to see every day where he went, what types of places he frequented, such as whether he went to bars often or went to health clubs or fitness clubs, or whether he visited certain businesses that were subject to criminal activity. Then a couple years after that, we had the Riley case. Riley involved a search of a cell phone, and traditionally, when people get stopped in a criminal in connection with a criminal investigation or a criminal stop, your person and effects, such as any papers that you have in your pocket and so forth, are subject to search incident to arrest. Riley's cell phone was searched. And this is an interesting, the reason that case is interesting is that the Supreme Court started to recognize that cell phones, with all the data that they contain about an individual and all the stuff that we store, and the fact that the cell phones are now linked to cloud storage that has even more information, really contain lots of the privacies of life about an individual. And the Supreme Court drew a distinction between a cell phone, an electronic storage device, and other personal effects on a person. And then finally, last year, we have Carpenter. And Carpenter was similar to Jones in the sense of tracking an individual's movements, but it was done through the authorities went to the cell phone company, and I don't know if most people realize this, but your cell phone is able to be used to track your movements through cell site location data, where your phone connects to, and you can track a person's movements. And so the law enforcement obtained cell site location information about Carpenter's movements. It was historic information over a period of several months prior, and linked Carpenter to the burglary of electronic stores, and ultimately used that as a conviction. And out of these cases, we get this idea of a mosaic theory of gathering information about a person and painting a picture of that person's life. And so that becomes relevant when we start looking at, again, things like Fitbits and other devices. So digging into, specific laws to be aware of in connection with devices, the first obvious one in the healthcare arena is HIPAA, the HIPAA privacy rule and security rule. But of course, as I noted earlier, HIPAA has limited application because it only applies to covered entities and business associates. And HIPAA also has an exclusion for de-identified data. And there's two ways to de-identify data under HIPAA. One, you can do it by expert certification, or another way is through a safe harbor mechanism in the regulation, where you remove 18 specific elements about the data, and then that data can be shared without being subject to the same stringent HIPAA requirements. Yeah, go ahead.
When you talk about expert certification, is that somebody who's certified to do this? Is there a special professional that's out there that has some type of certification on this?
Yes, yeah. So you have an expert who's certified to provide that certification on the data. And so it gives you two different processes before you can go have the data, essentially the anonymized, what is anonymized data can be shared. And so purportedly, that information, once it's shared, it can't be matched up to individuals. So there's really, it's much more innocuous than having specific information about people. But earlier we talked about the recent study in California, and Tony, you mentioned about matching people up. In fact, I read a statistic that if you have a person's just simple information such as a person's zip code and date of birth, you narrow down your population to generally one of 4 people. And if I know whether that person's male or female, I can narrow it down to 2, which I find just amazing. And then when you consider that you can get this data, and you might get, for instance, anonymized HIPAA data from a health insurance company or from a clearinghouse, and then match that up with Fitbit data. I say Fitbit, I'm using that really as a generic term. I have, for instance, a little device that tracks my steps every day so that I can get a discount on health insurance. And so you could get information like that that's not HIPAA data. It's just data that employees voluntarily provide about their daily activities, and then use that potentially now to re-identify individuals through machine learning and through artificial intelligence. And 10 years ago or maybe more than that, I forget who said it, Tony, maybe you remember, said, privacy's dead, get over it. And now you have these researchers in California saying de-identified data is a thing of the past. You can no longer be assured that information is de-identified because we can piece it back together using artificial intelligence.
Yeah, that's interesting. They say, and using artificial intelligence. I mean, because I think you can just do it in general. Let's take out the technical piece there. We're just capturing more data on people, and the more data we have, the more links we have, and so if you have a lot of links, you're going to be able to identify who this specific person is. Now, like, stores are starting to, as you walk in, they can tell who you are. And if they can try to match that with some of their sales data, they'll know what you bought last time. Similar, the airport's the same way. I didn't have to show my ID last time I entered the U.S. and just based on photo recognition. So really interesting stuff what's happening, but it is a little scary. I can see, for a lot of people who aren't used to having this information out there, and just think that they can be anonymized. It's almost like we need a VPN for life.
Yeah, and when you consider that, HIPAA has stringent requirements for anonymizing data, but when you read, if anybody's ever looked at the terms and conditions, I don't expect most people have, but it's kind of interesting. You go through terms and conditions for the Amazon Alexa or for the Apple home device. Apple specifically says that they only share information. Last I looked, and maybe they've updated it, I couldn't find anything about sharing on Amazon, on Alexa. But Apple says that they only share information once it's been anonymized. But outside of the regulated area of healthcare information subject to HIPAA, what does anonymized mean? And I think we're leaving that in the hands of each individual company. And that's important if you're on the other side. If you're developing one of these devices, or if you're getting this information and you're telling people that this information is anonymized, you want to make sure that that it is in fact information that can't be pieced back together, so you don't run afoul of FTC unfairness regulation or some other state or federal regulation for not giving proper representations in your terms and conditions.
Yeah, and as we hop through this law and regulation section, if anybody has a question, just feel free to type it into the chat here to try to make this a little interactive. But I know there's quite a few laws and regulations you want to hop through, so just.
And we're not going to spend it. We're not going to do a deep dive into any of these. We could spend probably an hour talking about each one of these, or most of these regs. I just want to give people an overview of the types of laws that potentially affect this area. And I think the reason it's eye-opening is that you also realize that it's a lot of the Wild West. So it might be helpful for developers, it might be helpful for professionals, for anybody advising, anybody developing any of these devices. If you're using the devices, people specifically in the healthcare world or in the privacy world. But this is just an overview, and a lot more detail is contained. I think we did provide everybody with a written outline, and so there's citations to regs and laws and cases and so forth that are available if you want that information, or if you need that, give us a call. So a couple other healthcare laws just to be aware of. I just want to touch on these. Is GINA is the Genetic Information Non-Discrimination Act. This is really just a limited law that applies to employers and health insurers, limiting the use of genetic information for predispositions or determinations. And then we have the 21st Century Cures Act, which really is focusing on research participants and public interest in the use of data. Again, a lot of healthcare, we think of a lot of privacy issues in the healthcare arena, but there's a lot of folks that aren't covered, including most of these device developers, unless you fall into the category of a business associate, which many of them do not. Really, the 500-pound gorilla in the area of privacy enforcement with respect to these devices, where we see the most enforcement activity, where people get in trouble. And I've dealt with this agency specifically in representing clients to make sure we don't run afoul of representations that are made in terms and conditions and privacy policies, and that's the FTC. The Federal Trade Commission essentially is the broad enforcement agency over businesses, not only privacy practices, but representations that companies make about what they do with this information and how private it is kept. And they cover all businesses, including some HIPAA-covered entities. The FTC issues regulatory guidance over health apps and devices and other types of information capturing and sharing that's not covered by HIPAA. The most recent FTC development was, I believe, Facebook was a $5 billion fine that the FTC was involved in pursuing. And the FTC, the enforcement mechanism here is the FTC Act. There's Section 5 of the FTC Act. You also have almost every state has what we call a mini FTC Act. It's essentially the state's Unfair and Deceptive Trade Practices Act, Florida has one. California has one that's a little bit different than Florida's. They have an unfair business competition law that can apply. But essentially, this is what the FTC relies upon when determining whether a company's representations about their privacy practices or security practices are unfair and deceptive. And we'll dig into what that means specifically. And why this becomes important is that, you know, especially smaller companies we run into, and Tony and I have both seen this, where, you know, companies will create, or rather than creating a privacy policy or terms and conditions, they just want to go pull something off the internet, slap it on their website, and say, okay, these are our terms and conditions, this is our privacy policy, but they don't really know what the language says. They don't really understand the implications of those policies, and oftentimes they're just not following those policies, and that's where you can run afoul of the law specifically.
Yeah, absolutely. We see that a lot, where people just copy somebody else's privacy policy or just terms, and just to have something out there, but definitely not a good idea.
Yeah, if you're doing that, you at least want to make sure you're following exactly what representations you make. So, you know, we talk about the FTC with unfair and deceptive conduct. Conduct, and those two terms have specific meanings under the FTC Act. So conduct that's unfair, these are things like failing to maintain reasonable security, or protect against known foreseeable threats, failing to make your updates as required. A big case, one of the first big privacy cases that came out involved a Florida company here, Wyndham, and one of the things that the FTC said that Wyndham did is their conduct was unfair because they did not have reasonable security over the information that was subject to their breach. We'll probably see the same thing here with the recent breach, I think, Capital One that just got hit. Every time somebody gets hit, this is one of the things they worry about is, you know, unfair conduct. So we use an example here, a medical transcription company that used independent typists to make transcription notes. They didn't encrypt data in transmission, and the result was that over 15,000 files were made available online, and that company got hit under the FTC Act and fined for unfair conduct. Now, deceptive conduct, remember the FTC Act prohibits unfair and deceptive conduct. Deceptive conduct can come about when you misrepresent the level of privacy or security. So if you put a privacy policy up and you say we encrypt all data at rest and in transit, and you don't, you can be hit for deceptive conduct. So, you know, we have a dental software company that told clients it encrypted data, but it did not encrypt that data to the industry standard. That was deceptive conduct under the FTC Act. Another one I think is really interesting here is because we see a lot of instances with companies who advertise or say certain things, but then they have, you know, you dig into the fine print, so to speak, and find conflicting information. And in one case, a company had, what they did is allowed patients of physicians to go online and author reviews that would be published online. And the patients were told that the reviews would be anonymous, that the patient's information would not be disclosed. And so people, you know, made comments about their providers and suppliers of medical treatments, and believed that their information would remain anonymous, when in fact the fine print of the terms and conditions allowed that information to be disclosed and shared, and the FTC hit that company, even though they disclosed it, because it was disclosed in the fine print where people wouldn't typically read it. The FTC said that was deceptive conduct. We've seen that in other instances. If you make certain disclosures that the FTC says are key or vital to your business, and you don't make those prominently enough in your terms and conditions, or if you bury them in some web page that's hard to find, the FTC can bring action against you. Another law that to be aware of, and I'm not going to dig into the FTC health breach notification rule, but folks should be aware that that's out there. If there is a breach of health data, this can be broader than HIPAA. So if you do operate a company, or if you're dealing with any of these devices and you have a breach of health information, you could fall under this rule. This rule will also look familiar to folks because a lot of the state data breach notification rules track the language that's in the FTC health breach notification rule. And so this rule requires notice when there's been an unauthorized acquisition of PHR identifiable health information that's unsecured and in a personal health record. And so each of those underlying terms that are in italics there, each have a specific definition under the rule. And I won't read the definitions for you, but they're in the slides. You have them. It's also in the rule itself. This is available on the FTC's website. If you want more information on this, please contact us and let us know. So note that you know, the information, it's not encrypted or destroyed. So there's a suggestion, and there's some safe harbors that are available both under HIPAA and under this rule if you keep your data encrypted. All the more reason to have somebody, a technical advisor like Tony and his company. I'll give a plug for Tony because that's who we use, to make sure that your data is encrypted to the industry standard, both at rest and in transit. And Tony can explain more about what that means. But important because it protects you if you have an issue with, for instance, a stolen laptop or phone or some other device, which we see all the time. If the information is encrypted that's on there and it's encrypted to the proper standard, it may exclude you from some, you know, what can be really for a business embarrassing disclosures to the public.
Yeah, we see it all the time. You know, people lose laptops, you know, phones. Just if things aren't nailed down or encrypted, particularly in transit, then it's going to be a problem. And you have to basically report it as well. So you're telling on yourself. So it's not like you can really hide that either, if you're staying within the law.
Tony, I know you advise other businesses. I know that, you know, well, I won't say any, but there's some other, you know, professionals that you advise, other law firms and professional groups. Is there a certain trend that you see, you know, specifically with devices connected? You know, this is our topic here is IoT devices and wearables. Is there a trend that you're seeing where people are overlooking the privacy or something that people need to be aware of?
No, I think the most basic is just to have a password on each device. So whether it's a PC in an office or your phone, you should just have at least a basic password on there, so it's just not open for everyone that can just come by. In a lot of offices, you'll see sticky notes with people's passwords on them. You know, that's just you know, a problem waiting to happen. So I mean, you want to at least have some basic, you know, security. I kind of describe it as like, you know, how you would park your car. I mean, you wouldn't park your car in the darkest spot of the parking lot and leave $100 bills on the seat. You know, you'd park under a light. You'd make sure you lock the doors. Anything of value you'd put in the trunk. I mean, so you know, just doing the basics helps a lot, and steers a lot of would-be hackers or just you know, opportunity grabbers away. So yeah, I think just doing the basics, having a password on devices. I mean, ideally, if you're not keeping data on the local machines, you're using, you know, a cloud provider that encrypts data or you know, otherwise keeps it safe for you with SSL so you can access it. I think that's like more of an ideal situation, but even the basic, everybody can have a password.
Yeah, the same thing we sometimes say in law. Just sometimes look at it, the basics and ways you protect yourself. A little bit of common sense can go a long way. So I have up here the health breach notification requirements, specifically contacting the media if it affects over 500 residents of a state or territory. And these, again, this should look familiar to anybody who's looked at any state breach notification requirements. It applies often with payment card information or other financial data or private data where you have to give notice to the residents and make sure that the residents get that notice. And if you're subject to one of these breaches, again, if you have to contact the media, it's always a black eye for a company, like it is, you know, for a couple that are out there right now. And why is this important? Specifically for anybody who develops these devices? Well, it applies to not only to companies that have that information, but third-party service providers such as app developers. So if you are a company that's developing a new app or device connected to the Internet of Things, and you have a breach, then you may not necessarily have to make the notice yourself, but you have to notify your client, who then in turn is required to give notice under the breach notice rules. And you can probably bet that they're going to want to pin this on somebody, like the Equifax breach of a year or two ago, and they're going to say, well, this was our subcontractor, or this was our provider, our developer who did this wrong, and they're going to blame you. When it comes to notices, also you take actions. There's specific steps in the reg. I'm not going to go through those specifically because this isn't a breach notification seminar, but I want you to be aware that there's specific language in the reg about making sure your notice actually reaches your customers and clients. So another good thing to look at if you're in this world at all, if you're dealing with these devices, the FTC issues frequently reports and guidance, and they publish these on their website. And generally, these talk about conduct that the FTC considers fair or unfair, or true or deceptive. And some of these reports are listed here. I look to these for guidance. It really takes some of the regulations that are spread out in different sections of the Federal Register and the Federal Code and the statutes, and puts them together into some common sense, pretty easy to read language. I think all of these reports I've listed here, I probably have copies of. You can download them and read them at your leisure. Generally, the reports are maybe about 25 to 35 or 40 pages long, oftentimes have charts and some other statistics and data. The statistic that we started off the webinar with, and we talked about a little bit in the last time we met, with respect to the use of phones and mobile devices and connected devices and health data and the transmission of that data, that was all pulled off of another government website. The FTC provides a lot of that information. Why are these important other than gee whiz? Is it gives some insight into conduct that the FTC considers unfair and deceptive, and it can give some insight into how the FTC or other federal agencies may treat somebody that they believe is not meeting the standards. And so it can give a window into an action that might look like an unfair or deceptive trade practice according to FTC regulations. And more importantly, for even for folks who don't, if you're not worried about the FTC coming down on you, or you don't deal a lot with federal agencies, if you're a business, I mean, we have a lot of businesses, and I've done this myself. The FTC issues has, for instance, a guide on affiliate marketing and what they consider fair and unfair actions in connection with affiliate marketing. And I specifically relied on that in connection with an unfair competition lawsuit between a private lawsuit between a client and another business that we thought wasn't meeting the standards. So for instance, if you're dealing with an entity or a business or a developer who's not using the proper level of security, you may rely upon the FTC guidance to support a private cause of action, maybe for breach of contract or for negligence against that provider. You can also expect that state and federal agencies will look to this for potential negligence claims, as will private parties. So if there's a breach, for instance, of a wearable technology has a breach, like a Fitbit has a breach, and the data is exposed, even if there's no government action, private parties may use the FTC guidance to set a standard, a baseline standard for what's required to avoid a negligence action. And you may rely, if you're representing a client, I've done this, and say, okay, well, if the FTC report says that we need to, encrypt at this level, or the FTC report says this is the reasonable standard of security, that may provide a legal defense in connection with a private lawsuit. So interesting stuff to take a look at. Again, if you have any questions about that, and I like that little cartoon.
Since the slide mentions ransomware, I mean, what's quite interesting is, we're worried about keeping other people's data safe, but also it's your own data, because it's, if somebody can get into your system and access the data, that means they can encrypt your files, they can hold you hostage. I mean, look at what happened with, was it the city of Riviera Beach, where their systems got encrypted, and they had to pay in Bitcoin to get a release code to unencrypt the data. So just keep that in mind, that you don't want to be a soft target.
Yeah, and we're specifically seeing in our practice a lot more potential negligence actions or unfairness, competition-related actions relating to a failure to maintain proper security or proper standards, or making misrepresentations with respect to what you do, both from business to business and business to client, and vice versa. So also want to mention certain tools. There's this one tool that the FTC has collaborated with other agencies, HHS and FDA, on for where mobile app developers, if you are in that world or representing anybody in that world, you can go and you plug in some information about your app, and then this tool online will tell you if you're potentially subject to HIPAA or one of the FTC acts or rules, or the Food, Drug, and Cosmetic Act. And so I give the link down there, but the best way to explain this, I think, is actually to kind of give one of the scenarios. I took this out of the interactive tool that's available on through the FTC website through that link. And again, remember, this information is available to you if you want to go check this out yourself. But here's the scenario that a consumer downloads to her smartphone a mobile personal health record app offered by her health plan that offers users in its network the ability to request, download, and store health plan records and check the status of claims and coverage decisions. The app also contains the plan's wellness tools for members so they can track progress in improving their health. And the health plan analyzes health information and data about app usage to understand the effectiveness of its health and wellness offerings. The app developer also offers a separate direct-to-consumer version of the app that consumers can use to store, manage, and organize their health records and improve their health habits to send information to their providers. This is coming, by the way. We have this, again, I mentioned I have a wearable device through our health insurance in the office. I've talked to several other people. This is getting more popular, that insurance companies want to, they say they want to keep people more active, so they incentivize you by giving you so many dollars for so many steps that you take, figuring, I guess, that healthier people are going to result in less insurance claims. But I wonder how much of it is also to help them just in their business analysis and so forth. But anyway, with this scenario, then the questions go through, whether or not you're subject to these laws. And so one of the questions is the app developer considered a HIPAA business associate subject to HIPAA? And the app gives this answer that yes, with respect to certain portions of the offering, but no with respect to the consumer, direct consumer app. And then it gives an explanation of why it's a business associate with respect to the health plan. Again, you can go check this out yourself, but want everybody to be aware that that tool's out there. It's pretty interesting to look at. And of course, whenever you're talking about a connected medical or connected health and fitness device, the question comes up whether or not it's a medical device, and that question is important because if it's a medical device, it's potentially subject to or would be subject to regulation under the Food and Drug and Cosmetics Act. And the important thing that I want you to take away from that is to understand the gray area and some of the issues surrounding the identification of a medical device. And a medical device is considered such when it's used to generally diagnose, treat, cure, or mitigate or prevent a disease or affect the structure and any function of any body of any man or other animals. So actually, I guess animal tracking, dog collars and so forth can potentially be medical devices. And if it's a medical device, then you're required to follow certain, get certain approvals and make certain disclosures under the FDA Act. Want to make a note that recent revisions under the FTC Act have excluded software functions and certain consumer-facing health apps from what is considered regulated medical devices. So there was some gray area before that, and under the 21st Century Cures Act, amendments were made that excluded, again, consumer-facing health apps, things that don't interact with providers and suppliers, and certain software functions. So the software itself was not considered a medical device. The FDA gives guidance, just like the FTC, on recommendations for security and privacy functions of connected devices. So it's worthwhile to check out the FDA's website as well as the FTC's website. Again, if you're in this world, or if you're looking for ideas on how to attack a competitor, you may actually go and look and see, is your competitor following these rules, or if you have somebody who's got a client that's got a beef with a certain device and they think they released information unfairly. Again, this might set the standard for a private cause of action based on negligence or unfair business practices, unfair competition, etc. These are some recommendations from the FDA that were released in 2014, which are still published on the FDA's website, but by today's standards seem almost antiquated. Finally, as we kind of roll through a little bit of law and regulation, and I want to make sure we remind people that if you have questions, you can fire them out. And if you have any questions that you don't want to fire out to us during the webinar, but you want addressed afterwards, please feel free to give us a call or shoot an email. Well, we've got several, I've almost given up trying to keep up on the various state laws and the various proposals for federal laws affecting mobile devices, medical and health privacy issues at a state level, but understand that there are certain states that have passed laws regarding the security of connected devices, most notably Oregon and California. California has a big privacy act that's about to go into effect, but it's been subject to a couple amendments. Biometric privacy, fingerprints, eyes, facial recognition technology, depending on the definition of biometric privacy, has been the subject of recent laws and regulation. There's a proposed law in Florida, but that one hasn't passed yet, so we'll wait and see what happens with that. And I want to give, because I know Tony's going to contribute on best practices, but finally I want to mention industry self-regulation, and this is similar. Two of the main organizations here are Medical Device Innovation and Safety Security Consortium, which is a nonprofit group from various areas in the medical device arena, and Exertia, which is a collaboration among the American Heart Association, American Medical Association, Healthcare Information Management Systems Society, and a nonprofit group called DHX, whose mission is to accelerate and development, market implementation of digital devices. These organizations become important, similar to the FTC guidance. While they don't have the effect of law, they do have strong lobbying effects oftentimes, and can influence law and regulation, can influence government agencies. Sometimes a recommendation from certain industry regulatory bodies, to the FTC or to CMS or HHS or some other government authority, can carry a lot of weight. So if you fall under the microscope of one of these agencies or one of these industry self-regulation organizations, you should pay attention to them. We see that in other areas, specifically in advertising with the FTC. And these, they're also useful because sometimes you can go to the websites and they provide guidance on practices that are considered fair and honest and reasonable with respect to mobile devices or health devices. And again, whenever you have an independent third party, whether or not that's a government agency or a private industry, where it's a respected organization or collaboration, that provides you sometimes with not only guidance on how to interpret laws and how to avoid running afoul laws, but also it can provide you with defenses in litigation. It can provide you with a certain baseline standard for what's considered acceptable and appropriate conduct. So it's worthwhile paying attention to what these organizations offer. So I want to dive now into some best practices, not only for companies that are developing these devices, but for users, for companies that hire the developers, and for the individual consumer, what you should expect. And we have a list of various best practices. Tony, what's some of the stuff that jumps out at you for what people need to be concerned with if you're developing a device like this, or if you have a client developing a device?
Yeah, no. Well, if you're developing a device, I mean, you want to make sure you're setting up your APIs correctly. That you're looking for. We have a whole list of items like for any kind of user input. You can't have malicious like SQL injections or things like that. I don't want to get too technical with folks, but I mean, we have a list of items that you would go through to check an application. And this happens a lot. Sometimes we'll do a security review either for an existing application, say for example, if someone's going to acquire that application or the company for that matter, and wants to make sure they understand what their exposure is, or if they just want a better peace of mind, they may have had developers in another country putting together the software and want to make sure they didn't leave any holes in there and just want to recheck their work. So yeah, those are just a few of the items, but I think you really need to just review the entire security architecture, and there's a whole assessment phase that you would have to go through if you're looking to purchase an application, or if you're going to be taking an application that you had developed in a foreign country and put it for use within the U.S.
Yeah, and all of these on development of new apps, development of new technologies, new software. We've collaborated before, you and I, on development projects and been involved in the sale of new technologies. It often requires expertise from various parties. So you're not going to have just technology, not just legal, operations, sales, marketing. It's going to be a group effort. And so from a legal perspective,
absolutely a group effort. I mean, it's a combination of skill sets. I mean, just like developing any application is today. I mean, you have designers, you have programmers, you have network specialists, you have security specialists. So I mean, we have a whole team that we put together to do that type of assessment.
Yeah. And so, just a little plug, for the firm we're going through right now, right before I got on this webinar, we're involved in helping a healthcare provider sell business to a large national group. And there's tax considerations, there's Medicare, Medicaid change of ownership considerations, regulatory concerns, and business concerns, due diligence, corporate structuring, real estate, and leases, and then of course you have the technical aspects. So we might have 4 or 5 people. I've been on these group conference calls where in our office we have 4 or 5 people on a call, and we're on with 3 or 4 other groups trying to push towards the finish line. So it's rare that one person is going to be able to answer everything, but we certainly will try to point you in the right direction. So
yeah, I think that's just how things work today. I mean, it's a collaborative effort.
And there's a lot of advantages to being in a group. So it's nice to be surrounded by smart people. I want to give a little shout out to you, Tony, and say thank you again for joining me. A lot of this technical stuff I talk about, but I don't understand it near as well until after Tony explains it to me or boils it down in a language that I can understand. As we finish up, other best practices, I mentioned FTC several times. They give a list of best practices that's available through their website and various guidance. And finally, why is all this stuff important? Check this out. Where the future of these devices. So just recently, this is the Office of National Health Coordinator published a proposed rule in the Federal Register. This is the guide where federal regulation goes to get comments and ultimately be passed into law or modified according to what the comments are. So they published a proposed rule just within the last couple of months, and it's intended to make it easier for individuals to use apps to access, view, and share their online medical data by making electronic health information accessible through APIs. And Tony can explain maybe a little bit more about what that means. But the rule would, again, promote the interoperability of health information technology and allow the exchange of electronic health information for care and other appropriate health purposes. So we're going to get more technical when we talk about making the information accessible through APIs. Tony, can you give we got 2 minutes unless we have a question.
Sure. An API is just what they call an application programming interface. So it's think of it like a bridge to connect to programs. So it's a way of passing data between different systems. So it's you create an API for your app. So you have a standardized way for people to get in and out, move data in or move data out of your application.
And so by doing that, if I have my app and now I want to connect with another app through another developer, totally unrelated, who I don't have any control with, an API allows those two to interface to facilitate the exchange of information. Is that correct?
Yeah, exactly. And you're defining if it's your API, you've defined what data can be accessed and how it can be accessed, and what the terms are, and then that person would then, or that other program would then send a command with that structure of information and be able to capture that. So it's just a bridge between there. You just set the rules between what we're going to communicate and how it works, and then the two you can program it on both sides. And the bridge is there. You can pass the data back and forth. That's allowed by the API.
And so the big takeaway from that essentially is that the federal agencies that matter realize that we need to help facilitate the community. They're not trying to shut down these technologies. They're actually trying to make the technologies more streamlined, in my view. But when that happens, they're also going to be very stringent about the security and privacy standards that are in place in order to protect people's basic information.
It's more streamlined, but it forces you to think about what information you're going to allow, and which, if I'm going to allow someone to request certain data from my system, I mean, is it in my API or not? Because you have to define this ahead of time. It's not like they can just request anything. So which data you're willing to send and receive. So it forces, I think, folks a little bit of due diligence for you to put together the API, and then it does indeed streamline the overall system and the interactivity.
Well, I was looking to see if we have any questions, and I don't see any, but I want to thank everybody for joining us today. We had a nice group on.